Today we'll be talking about plagiarism in law school and in the practice of law, and how plagiarism in terms of the consequences might differ from what you've experienced in undergrad or even in another graduate program, and certainly from what you might have experienced in high school. So first of all, let's start with what plagiarism is. Black's Law Dictionary defines plagiarism as the act or instance of copying or stealing another's words or ideas and attributing them as one's own. Now, the thing that's a little bit tricky about this is that attributing them as your own doesn't require an extra step. There's no extra thing that you do when you attribute them as your own that specifically and affirmatively says, these are my words. Simply by providing them in a format where they're not attributed to someone else, they're automatically attributed to you. So you have to be very careful about this. The Toro Student Handbook says that a student plagiarizes when the student submits the work of another as the student's own. Plagiarism is the copying of the work of another without fully crediting sources, the improper paraphrasing of the work of another, or the use of ideas or text obtained from another without fully crediting sources. So what plagiarism is, as far as law school versus law practice, it's a little bit different in law practice. And that's because in law practice, what's more important is the result that you get, and not necessarily whether you specifically drafted every word. In law practice, those of you who've worked in law firms, you know that there's software, you know that there are form books, you know that there are online forms that you can use and fill in the blanks. Now, whether or not that's a particularly good way to practice law is a discussion for another time, and also for some additional courses. But those things do exist where you can sort of plug and play with the forms. In law school, it's different, because in law school, we have to know what work is yours and what work belongs to someone else, because we have to grade the work and assess it and determine what your skill level is. And the grade that you get at the end of the course, and certainly the grades and the assessments you get throughout the course, are your professor's assessment of your skill level. And so that's what goes into your final grade that employers will look at. So we need to know what you're capable of, not what someone else is capable of that you simply tweak a little bit. So the difference in an academic setting is that every single word has got to be yours unless you have attributed it or quoted it. In law practice, as long as you're authorized to use another's words, you don't necessarily have to quote them with respect to things like forms and arguments. For example, some law firms have a brief bank where they have issues that come up over and over again, and you can go to that brief bank or that motion bank and you can pull another lawyer's submission in another case that might be similar to yours or might raise the same issue. And you can take that and adapt it because you're an authorized user of that brief. Now, there is still plagiarism in the practice of law. If someone from another law firm stole that from your law firm, tweaked it for their argument and submitted it, that would be plagiarism. So the consequences of plagiarism. The Toro College Academic Integrity Policy sets forward the procedures for prosecuting a plagiarism case or for handling a plagiarism case, and then the penalties that might come from a plagiarism case. They start at informal resolution. An informal resolution is where the student admits that there was plagiarism, and the professor and the student work out a consequence together, and the dean of students signs off on that. Then there are formal resolution consequences that come after a hearing before a committee. Those range from a warning or academic probation all the way up to suspension or expulsion. And there are allowances in the policy for other penalties that may be determined to be fair under the circumstances. So sometimes the committee that hears plagiarism cases may fashion a penalty that fits the particular student in front of them or the situation a little bit better than the cookie cutter consequences in the Code of Conduct. Now, here's where plagiarism consequences differ substantially in law school from other areas of study and other levels of study like undergraduate. There are consequences for your bar admission. And think back to the hypothetical that we've been working with in class, plagiarism and the bar examiners. Remember that most of those cases were people who were applying to admission to the bar, and it was discovered that they had plagiarized in law school. So their law school plagiarism, and in some cases their undergraduate plagiarism, came back to bite them in the bar admission process. Any allegation of plagiarism that's made against you in law school has got to be reported to the bar examiners regardless of the disposition. So any charge that's leveled against you for plagiarism through a formal process has got to be reported to the bar. And in fact, even informal resolution, because it involves some formal processes, has to be reported to any bar to which you apply. And so even the allegation of plagiarism, regardless of the disposition, would be reported to the bar. So you want to stay as far away from plagiarism as you possibly can. It's much better to over-attribute your work than to under-attribute your work. Remember when we talked about citation at the very beginning in that first trio of videos that you watched before you started the ICW exercises. Remember that I said that in the law, more attribution makes your argument stronger. In the law, we don't want original rules that come from individual advocates. We want well-settled rules that have been articulated by courts over and over and over again. And so the more you cite, the stronger your argument is within reason. We'll talk about string cites in another video. So there's no benefit to under-attributing sources in your work, and there's no penalty to over-attributing. The worst thing that will happen if you over-attribute, which is basically a long string cite, is that you might annoy your reader. That's it. But if you under-attribute in your document, you can find yourself having trouble in front of the bar examiners when you try to gain admission to the bar. The temptation of plagiarism is usually not deception, and that's why intent isn't required for penalty. The basis of plagiarism, or the origin of plagiarism, it's about the theft of ideas and the sanctity of being able to lay claim to one's own ideas. And that's why intent isn't part of this, and it's not required for penalty. You can accidentally commit plagiarism and still be penalized, just like you can accidentally speed on the parkway and still get a speeding ticket, even if you didn't intend to. So it doesn't matter if you intended to plagiarize, it only matters that you did. Usually the temptation is, particularly in your first year of law school, it's fear of changing something that's right to something that's wrong. And so a lot of times when you have to commit something to writing, you have to do that before you feel like you have a good solid handle on it. And so sometimes you want to use the original words just so you can avoid paraphrasing your way into the wrong statement. The solution for that isn't not to attribute the source. The solution for that is to quote the source, if that's what you really want to do. The other thing that's tempting about plagiarism goes hand in hand with that, and that's a lack of understanding of the material. If you don't understand the material, you may feel insecure putting things into your own words. So up next, we're going to talk about avoiding plagiarism through proper citation and quotation practices so that none of this ever darkens your doorstep.